All right, good afternoon, welcome. Apologize for the delay there, but we're ready to get started. We are gathered this afternoon to consider whether the appeals of exclusion from the parks will, against Helen, Cruz, and Justin Wallace will be upheld. And we will start off with opening statements from staff.
Good afternoon, Mayor Council. So today, as stated, the issues before you is whether or not the park exclusions that have been lawfully issued to Helen Cruz and Justin Wallace are going to be upheld. Before we get started, I want to just do a short background on the laws that we're going to be dealing with today. So today we're going to be dealing with GPMC, Grants Pass Municipal Code 5.61030, which makes it unlawful to camp on publicly owned property. GPMC 6.49.090, which makes camping in parks unlawful. GPMC 6.49.350, which is a park exclusion ordinance. The judgment and injunction from the Blake versus Grants Pass case. And GPMC 5.12070, which deals with scattering rubbish in the park. So, enforcement happens pursuant to our code and our injunction. The injunction states that the city may not enforce its camping laws between the hours of 9 to 7:30 from April to September, and 7 o'clock p.m. to 7:30 from October to March. Furthermore, the injunction requires that an individual is given 24 hours notice before the camping ordinances are enforced. Now, the park exclusion ordinance has been revamped since the injunction to provide for a process, an appeals process that allows the individual to stay in the park while the appeal is pending, to make sure that there's a procedure for the person to be heard, and to make sure that the park exclusion applies to only the park where the offenses occurred and not to every single park in the city. Staff, through its witnesses, will provide testimony that Helen Cruz and Justin Wallace have been camping at Morrison Park, the park in question, for months. Staff to date, or at least before, has not taken action to forcibly remove them from the park. Staff will establish that the appellants repeatedly violate the rule that camp has to be broken down by 7:30 in the morning. Finally, staff will prove by a preponderance of the evidence that 1, Helen Cruz and Justin Wallace, within a 1-year period, received 2 or more citations in Morrison Park for violating regulations related to city park properties, related to camping. And Helen Cruz and Justin Wallace were given more than adequate notice for their illegal camping pursuant to the injunction that the city is under. The question before you is not the validity of the citations, that's a judicial matter. The question before you is whether or not the park exclusions that were issued as a result of these 2 citations are to be upheld. So, to summarize, staff seeks the upholding of the park exclusions for 30 days pursuant to GPMC 6.49.350 to be effective immediately. That's all.
Thank you. And the appellant has the right to opening statements, and I'm sorry I didn't say this earlier, but opening statements should be limited to 5 minutes.
Hello, good morning, afternoon. What is time? Time matters, actually. We'll talk about that in a second. Nice to meet all of you. This is the first time I am standing before the City Council. My name is Brodia Minter. I am representing Ms. Helen Cruz and Justin Wallace today in the matter before you. First and foremost, I was provided the way in which this procedure was going to go maybe 1.5 minutes before the city attorney was to take the stage. So The right to appeal in the municipal code doesn't provide any description for what the procedure is and how to follow it the way this paper does. Thank you for providing it to me. However, up until that moment, I had no idea how this hearing was to be conducted. Okay, so I haven't been put on notice up until I spoke to city attorney outside prior to this hearing that they would be calling any witnesses. Therefore, I did not have the opportunity to prepare any cross-examination questions for any witnesses, given that I didn't know who they were going to call. My client has been denied their very reasonable request for a copy of body cam footage from the alleged officers in these interactions, and we were denied that request. And so we ask that this hearing be stayed until that evidence is provided such that I can have adequate time to prepare in the defense of my clients. And I can get up here and say the same thing for Mr. Wallace as well. I believe that we're starting with Ms. Cruz, but no one has really told me again which we're doing two separate hearings, which one's first, right? So I think those are really important things that should be foundational before this proceeds. As you all know, City of Grants Pass is under a federal injunction, and I brought 10 copies of that court case with me in hopes that we could go through it together if you chose to proceed. But my first question is, why are we proceeding prior to receiving the detailed order of procedure for this hearing? I also just would like to state that further on the agenda today, you're addressing concerns of unhoused people, and I believe some report of that, and I think that would be very much relevant to this proceeding as well, and I would request at the very least that we go after that. Again, I don't know if I'm speaking for Ms. Cruz or Mr. Wallace yet, because that has not been provided. But in summary, if we choose to proceed today, we are asking the City Council to dismiss the exclusion orders against Ms. Cruz and also Mr. Wallace. We ask that the city codify a meaningful procedure policy so that anyone who wants to appeal any ordinance or any, violation of the municipal code knows how to do so without getting counsel, and if they have counsel, so that that counsel can adequately prepare for that. This is a due process. We also request that the City of Grants Pass acknowledge that they are in the violation of the injunction by Magistrate Clark in the Blake v. Grants Pass case, where they are enjoined from enforcing the municipal code without a stay pending appeal. The City of Grants Pass attorney asserts that these ordinances were amended to address the procedural due process rights. However, until I requested that this proceeding be broken up into two different hearings, we were going to do one hearing for two different people and two different appeals. And if Grants Pass is concerned about due process rights, that should be at the forefront. One hearing per appeal per person, right? However, the exclusion order in question today was given on 5/31. That 5/31 exclusion order was cited until 6/3 at 11:15 for the property to be out. However, on 6/2, prior to 6/3, another exclusion order and a citation was given to Mr. Wallace and Ms. Cruz. They're following the piece of paper handed to them, yet they're getting swept and they're getting citations. Since then, they've been swept from the park on 6/3, re-noticed for illegal camping on 6/4, cited for illegal camping on 6/6, and on 6/6, they cite that 5/31 exclusion notice from the park as the basis for that citation. I thought we're staying that until we're heard. They were then cited on 6/9, on 6/13, and all 6/16, all without staying the executive order. So that is my first request, and I request that you respond.
Thank you for your opening statements. I'd like to have Mr. Agu answer a couple questions. Hello. What information was provided ahead of time about the order of the procedure today?
The documentary evidence and the order of procedure that you have in front of you was sent to Helen Cruz weeks ago. Ms. Minter called our office on Thursday, informing me at that time that she would be representing Ms. Cruz. At that time, it was just Ms. Cruz. Ms. Minter and I had a conversation. She requested that the hearings be segregated into 2 separate hearings. So instead of 1 hearing, which is all going to deal with the same evidence in the same park with the same 2 people, we decided that we would break it into 1, as noticed, Helen Cruz and Justin Wallace. So this isn't a court proceeding. All of the evidence has been given to the defense. The procedure was given to Ms. Cruz. This is not a surprise. This has been in the works for almost a month. It is now June 27th. The citation that resulted in the park exclusion was effective on June 2nd. So this information was passed on to the appellants weeks ago.
Counsel, do you have questions? Brian?
So you mentioned that the appellant's attorney requested that procedure on Thursday? Was that provided?
No, she did not request that procedure on Thursday. It was not requested. She requested that procedure today after saying that she'd never received it.
But she did contact you Thursday?
She contacted me on Thursday as it related to the representation of Ms. Cruz to talk about the park exclusion hearings being segregated for Helen Cruz herself and then Justin Wallace himself, even though the 2 were going to be tied because they all involved the same evidence. She also did ask for a copy of the injunction, which I did provide to her on Thursday. Ms. Minter did tell me that she was going to be out of town this past weekend. And we didn't have an opportunity to talk until about 15 minutes before. And then I informed her briefly that counsel was going to be getting a copy of the procedure, which I had sent previously to counsel. It just wasn't on your dais. I informed her of the same, and she asked for it. And at that point in time is when she claimed that she didn't receive it. And of course, she can come up here to answer for that as well. So I'm not putting words into her mouth.
Thank you.
Joel?
So, sir, when did you send this order of procedure to the?
I'd have to check my
defendant?
email. I'd have to check my email, but I sent it directly to Ms. Cruz's email.
Okay, and that was approximately
It was a couple weeks ago.
a couple weeks ago. Okay, thank you.
I can get an exact date for you.
Vanessa?
When will the council have an opportunity to review these documents? I have a couple dozen
So
pages here.
the intent is to go through the evidence. So the reason that I didn't have counsel review the documentary evidence beforehand was because Ms. Cruz and Mr. Wallace didn't have an opportunity to send you what they were going to introduce. So I didn't want to create a situation where you're looking at the information that I provided, but not the information that they provided. So instead, we're going to have the hearing where all of the evidence is going to come out in an open forum so that there's an equal opportunity to be heard.
And it's my understanding this is kind of unprecedented territory, that we haven't had this situation in the past of an appeal of a citation.
Yes, this is, as far as I'm aware and as far as my tenure as city attorney, this is the first time that we've engaged in something like this. To my knowledge, the appeals process in the order of Blake versus Grants Pass was ruled to be procedurally in terms of procedural due process to be inadequate. My understanding is that shortly after the judgment and injunction was signed by Judge Clark, City Council amended the park exclusion ordinance to satisfy those issues in conjunction with outside counsel to satisfy those issues that were in Judge Clark's order.
Other questions, counsel? Brian?
It's not so much a question, but there's the impression that the defendant may not be in a fair and equitable position given that they didn't know the procedure ahead of time, and that this is the first time we've done this, and it's not totally flawless. So I would move that we stay for 2 weeks and then reconvene after the defense has had a time to review all the information regarding the proceeding and the structure, and form, their defense based on the structure that the staff has had an opportunity to do.
Is there a second? Vanessa with the second. Any discussion on the motion
I
for
think
the stay?
Councilor Ogier has a question.
Question?
I actually would ask for an amendment to that motion if we could separate the two appeals and treat them as separate appeals.
We can, if that's formal action to do it, that's fine. I mean, and whatever council decides today, staff is comfortable with. It's really up to you.
Okay, so the motion was to delay the hearing for at least 2 weeks, or 2 weeks from today, is that your motion? In order to allow the appellant an opportunity to review the documents. Is there any further discussion on that? All right, question, Joel?
So I would ask both parties, information that was provided to the defendant evidently wasn't given to the counsel, or to her counsel. So she received the procedure and it wasn't given to the counsel. Is there any other information that was sent to the defendant that the defendant may not have shared with her counsel?
Not to my knowledge. Everything that is in that packet in front of you, which I will be taking back should council decide to stay, everything in that packet has been provided to the appellants. That was also provided to Ms. Cruz prior to her engaging with Ms. Minter as her counsel.
Okay, thank you.
Valerie?
Yeah, I just kind of want clarification. So, yeah. So basically, you're saying that they did receive the information. Mrs. Cruz did get the information 2 weeks ago. Am I correct?
Yes, more or less.
And so that the time delay was between when it was received and when they got legal counsel. Is there any sort of, am I correct in that?
Yes, so there was the time delay because I don't think at that time, or at least 2 weeks ago, this matter hadn't been scheduled for a special hearing as of yet. And at the time, I was operating under the assumption that Ms. Cruz would not be represented by counsel, so I was corresponding with Ms. Cruz directly. I've corresponded with her on the phone and through email. Since I haven't corresponded with Ms. Cruz since she retained counsel, which apparently was last Thursday. I've only been, and the only contact that I've had with Ms. Minter is Thursday. Well, when I met her in my office, that was once, but she wasn't acting as her counsel for the purposes of this hearing. Then on the phone last Thursday, and then today, just about 15 minutes before the start of the hearing.
And so my second question is that was it agreed that they would be separated at that point in time and we would be doing Ms. Cruz separate from Mr. Wallace?
So in our Thursday conversation, and again, I would invite Ms. Minter up here to speak if she thinks that I'm misrepresenting our conversation. She brought up concerns about having the hearings placed together. And while I pushed back on it, I ultimately consulted with the city manager, and the city manager determined that we would notice the hearing as 2 separate hearings and that we would conduct 2 separate hearings, one from Ms. Cruz and one from Mr. Wallace, in the order that was noticed in our packet, in our agenda.
Okay.
Okay, so it's already been determined that we will be conducting 2 separate hearings.
Yes.
Okay,
Mayor.
my apologies, I did not understand that. Okay, so the motion right now is to stay the hearings for 2 weeks. Discussion on that?
If I just may concur, if you don't mind.
Sure.
I believe Mr. Abu did accurately represent our conversations. I'm just, would like to remind the city council that the reason that we're asking for the two separate appeals, for the two separate individuals, for the two separate ordinances that were given, is that under the injunction of Blake v. Grants Pass, was that the class action lawsuits group didn't get their due process rights met, and so that's why I requested that. Mr. Agu did have a different opinion, but he ultimately agreed and did provide that. When I approached in terms of what hearing we were starting with, given Mr. Agu did not address that, and I don't have a copy of your agenda, and I just got this procedure a couple minutes ago, I didn't know which hearing we were starting with, and that's why I wanted to bring that to the table. I did speak to Mr. Agu on Thursday and notified him of my representation. At that time, he did provide me a copy of the injunction. He did not provide me a copy of this document, though he says he did provide it to my client, and I can't say whether that is true or untrue. And I take absolutely no position on that. Though now I have it, I will diligently prepare. I've been preparing for this all day today. And because I think this matters, and I think that it should be heard, and be heard with a fair shot. So I really appreciate that motion and the opportunity to prepare. The only evidence that I would request, since we're talking about testimony and what was told to my client regarding when they can and cannot be in the park, I do request the body cam footage of these officers for those dates in question. And I would like to offer that as evidence on our behalf. That's all. And I am available for questions.
If I may, on that point, officer cam footage is not typically subject to public disclosure in the state of Oregon. This is not a criminal case. This is not something that is being decided by a tribunal of judges, your city council. Issues regarding the citations are a judicial matter. If Ms. Minter wishes to seek that evidence, she's free to do so through the public records requesting mechanism set forth by Oregon law. However, I must note that officer cam body footage is not typically for public disclosure in the state of Oregon.
And then if I may respond to that, I would just request that the hearing is set out long enough for me to able to make those requests, receive that footage and review it. I recognize that this is not a criminal proceeding. However, in reviewing the procedure in which y'all have proposed for this hearing to go, I commend you because it looks like a judicial proceeding. We have opening statements, we have direct examination, cross-examination, redirect, and then the end of this case in chief for the city, and then I'm able to put on my defense, which is literally the procedure for a trial. And so that's why we request that.
Chief, could you please let us know what is your standard procedure when somebody requests body cam footage?
Good afternoon, Mayor and Council. The city attorney was spot on with his assessment.
So you generally would not release it to anybody?
Correct.
Okay. Council, any other questions or comments regarding the motion to stay this hearing for 2 weeks?
I have a question, if you don't mind.
Go right ahead.
I appreciate you, thank you. Is it that you just won't release body cam footage, or is there a
Okay.
mechanism?
No,
in which I
I'm
can
going to stop
request
that.
it?
We asked what his standard procedure was, and he answered. That's good enough. All right, council, discussion? Okay. Brian, you made a motion to stay the hearing for 2 weeks. How do you vote?
Yes.
Councilor Ogier?
Yes.
Collins?
Yes.
King?
Yes.
Lovelace? Yes. Pell?
Yes.
Motion passes 7-0. Brian?
Thank you.
I had a question, since we're done with the motion now, I had a question regarding the body cam footage. If council so chose, could they make an exception to allow the defense to review the body cam footage?
Body cam footage is not generally subject to public disclosure under public records law in the state of Oregon.
So you say generally not, but if council so chose?
I don't think so. I don't think so, but I'm going to have to research that issue. Staff wasn't even going to use body cam footage.
That'd be good to know if council could be made aware once you find an answer to that.
I will diligently search for an answer to that question. I'll
Thank-
make sure I try to get it by the end of the day, either today or tomorrow.
Thank you.
Councilor Ogier, was your question from earlier satisfied?
Yes, thank you.
All right. Any further questions, discussion about this before we adjourn? Brian?
So we're going to have these documents taken back even though we've already reviewed them? Is that,
So you've reviewed the packet that I asked was not to be reviewed until the hearing started.
well, the hearing started, hasn't it?
We were going to present evidence in an open forum.
Was I the only one that was unclear that once it started, we could look at it?
I think that there was some confusion. It has been sitting on the table here for 2 hours, so let's adjourn. And we will reconvene this 2 weeks from today. Motion to adjourn?
I move to adjourn.
Thank you. Kurt with the second. All in favor of adjourning today?
Aye.
Any opposed? All right. Council, I will see you next Wednesday.